This bill be now read a second time, and I give the call to the member for Fowler.
Thank you, Speaker. I rise to speak on the Fair Work Legislation Amendment Protecting Work Entitlements Bill 2023. As a refugee who settled in southwest Sydney in the 1970s, at a time when migrant worker exploitation was rife and far more the norm than it is today, I'm glad to see more awareness raised for newly arrived migrants. In the past year, we have seen continuing commitments to improve the employment law space, specifically in reference to the enactment of the Fair Work Amendment, Secure Jobs, Better Pay Act 2022. This piece of legislative amendments has brought upon a paradigm change across the area of workplace bargaining and the approval processes involved therein. The Protecting Worker Entitlement Bill seeks to address a range of areas: migrant workers, unpaid parental leave, superannuation contributions, workplace determination, employer-authorised deductions and coal mining long service leave scheme. As you are aware, Fowler is a diverse electorate with 52% of the community being born overseas. Australia will welcome a further 650,000 migrants this financial year, with conversations that Fowler will likely be the majority's place of settlement. This expected migration boom naturally leads to questions of vacancy, lack of infrastructure, living costs, employment, which our faithful City Council has previously raised. Now, I raise the point of these figures due to the correlation to the proposed amendments put forward by the government. It's my understanding this will seek to achieve three major things on a policy level. One, relieve the fear of uncertainty of migrants seeking employment or within employment on where they stand in the Australian employment law system. Two, reduce exploitation of migrant workers. And three, result in a positive impact for migrant workers. According to the explanatory memorandum, irrespective of the immigration status, migrant workers would be entitled to access the benefits enshrined under the Fair Work Act. I perceive this as a significant and positive outcome for migrant workers within Fowler, and I welcome this development. For those who have gained the right to work, you can appreciate that there may be difficulty navigating the new culture, understanding their rights and obligations, particularly what exploitations could look like. The sad reality is that migrant workers may not recognise workplace exploitation when faced with such experiences, as everything in a new country would feel foreign to them. Exploitations could be in the form of underpayment of wages, working ridiculous hours, unsafe working environments, discrimination, bullying and harassment. It would not be obvious to migrant workers on what workplace practices are legally acceptable or unacceptable. In the Migrant Justice Institute submission for this bill, they note that their 2016 survey of over 4,000 temporary visa holders found at least a third were earning less than $12 an hour. An ABC report published today revealed the disturbing data within a report by the Grattan Institute that between 5% and 16% of employed recently arrived migrants are paid below the national minimum wage of $21.38. The Grattan Institute report published on the 7th of May 2023 further revealed that young migrant workers aged between 20 and 30-year-olds are more than 6 times likely than 30 to 40-year-olds to be underpaid by more than $3 per hour vis-a-vis the minimum wage. If you put this into perspective, these individuals could be your son, daughter, brother or sister that are being underpaid. This is literally wage theft. Mr. Speaker, how is this acceptable employment standards in Australia? If Australia is opening doors to migrant workers, we have a duty to ensure that there are adequate facilities, infrastructure, measures for the protection of their rights. A case that received media coverage in 2021 surrounded a cheesecake business with shop chains located in the Fowler electorate. The owners were accused of human trafficking and slavery, with alleged threats of exploitation made to the employee being detained to work illegally. It was reported that the individual worked at the cake shop between 2015 and 2017 unpaid. When this story was released, it was a major shock to our electorate that such atrocity can occur within our neighbourhood in this day and age. This begs the question, how could Australian laws have protected him better? Now, this is an isolated and sensationalised case, I understand, but like I said before, often enough data of migrant workers' exploitation will not be readily available. This is why this is scary to think about it. A further concern would be, what about migrants without appropriate working rights and their risk of getting exploited in the workplace. I'm talking about individual asylum seekers in Australia holding short-term bridging visas, pending an outcome, such as those who are on the temporary protection visas. Today, migrant workers within the Fowler electorate, including individuals holding the temporary protection visa and of diverse linguistic backgrounds. The Albanese government has since introduced the subclass 851 resolution of status visa to convert applications from temporary protection visas to one of permanent residency. There are also migrant workers on skilled visas. While the government has sought to amend this, as flagged by the Western Sydney Migrant Resource Centre, it's not a guarantee that all the TPV holders will definitely be accepted into this new stream. Acting CEO Mohan Gunasekara told our office that on the ground there are still inconsistencies with the TPV's visa, with not all the holders having working rights, and this depends on their circumstances, and the circumstances are not clear. While these migrants live in limbo, there are greater risks of exploitation. This is because their visa would not have working rights. These individuals may feel pressure to enter into workplaces and be undocumented to have a means of income. These factors would push them to be on the edge for employment that are not, quote-unquote, on the books. We've had a number of constituents call into our office to seek assistance on whether their bridging visas will allow their working rights, them to work. Time and time again, they were disappointed that they do not have lawful rights to work. Of course, I could not be of any further assistance to them in this regard. As you can imagine, these individuals' hands are tied until they have been processed by the Australian government. Fowler is and always will be a settlement city, and we are always welcoming of migrants. Our roots began from the post-Second World War with German and Italian communities settling here. We then had the Southeast Asian wave in the 70s and 80s, followed by the Latino, Eastern European communities of the 1990s and 2000s, and today where we welcome those from Africa and the Middle East. We are a multicultural melting pot, Mr. Speaker. Naturally, I'm concerned with the adequacy of the legislative measure to address the potential workplace exploitation. I iterate that if more migrant workers are to settle in Australia, particularly within the Fowler electorate, it is our duty to ensure that they are properly protected. Mr. Speaker, whilst I've raised concerns on migrant workers' exploitation, I acknowledge that this amendment under the Protecting Worker Entitlements Bill is a step forward. This legislative amendment sends a strong message. Migrant workers are to be treated as normal Australians with parallel working rights. Exploitation is not acceptable and things must change. But we can do so much more. I invite the government to consider the broader implications to best protect migrant workers. 1. Does this bill address the blurred lines of migrants without working rights and their risk of exploitation? Where do they stand in this interplay of the Fair Work Act and Migration Act? 2. Will there be a correlating amendment in the Migration Act 1958 to address these issues? The government should consider a legislative amendment within the Migration Act 1958 to clearly stipulate that a migrant's worker visa will not be at jeopardy of being cancelled if they have been exploited by the employer to work unlawful hours beyond their working rights. 3. Will there be greater resources to support the influx of migrant workers, like employment opportunities and infrastructure? In cases where migrant workers have appropriate working rights, will there be amendments to accompanying labour law frameworks outside the Fair Work Act to protect migrant workers? This was specifically raised in the submission by the Migrant Justice Institute. 5. And are we doing this absolute most to set up our migrants for success, such as social services, such as English classes and trauma counselling for those who have fled war or humanitarian crisis, in an absolute necessity to ensure we nurture them and help them in settling in their new life in Australia? I acknowledge that the above suggestions will be part of an ongoing commitment and look forward to the government's response to them. This will not be an overnight job. However, I propose that greater certainty be provided in the proposed provision to bring the objective of allowing migrant workers to enjoy the benefit of Fair Work Act to fruition. Accordingly, I propose that an additional statement be inserted at the end of subsection 40B2, quote, "To avoid doubt, this subsection ensures that a breach under the Migration Act 1958 or an instrument made under it does not affect the validity of a contract of an employment for a migrant worker under the Fair Work Act 2009, and that the migrant worker will be entitled to access the rights governed by the Fair Work Act. I trust that the amendment proposed above will be more greatly serve the mission of protecting migrant workers in Australia, which have opened new doors for, for people like them and such as myself. Thank you.
And I thank the member for Fowler.